Either podium.
Kids may never
okay.
wash their foreheads
Would you
again.
state and spell your name for the court reporter, please?
My name is Laura Kogan, first name
Ricky
Laura,
Fowl, now what is
last
he
name
doing? Speaking of
Coggin.
artistes, little
What is your
artwork.
occupation, Ms. Kogan?
I'm an assistant public defender.
Does that mean you're an attorney?
Yes, ma'am.
How long have you been practicing
Make it
law?
a double.
18
Kids may
years.
never wash their foreheads
And were you
again.
previously employed by the state attorney's office?
I was here in Nassau County for 8 years.
And were you assigned in the public defender's
Ricky
office?
Fowl, now what is he doing?
State versus Patrick
Speaking of
McDowell?
artistes,
I was.
little artwork.
Were you asked to monitor and gather media reports regarding this case?
Yes.
When did you begin gathering media reports
Make it a
relating to this
double.
case?
Immediately
wash
in
their foreheads
2021, in
again.
September of 2021.
And what did you look at when you gathered media reports?
Ricky Fowl, now what is he doing? Speaking
I
of
would look at
artistes, little
every
artwork.
news station, every major media outlet, locally as well as regionally and even
Make it a
nationally,
double.
looking for
Kids may
stories
never
that were
wash
written
their
about
foreheads
Mr.
again.
McDowell.
Did you create a spreadsheet with the television media related?
Ricky Fowl, now what is he doing?
I did.
Speaking of artistes, little artwork.
This is a lot more art than science here, and Ricky is
I do.
great with these young fans.
What is
Make it
that?
a double.
That is the
Kids may never
spreadsheet that
wash
has to
their
deal with the
foreheads
local
again.
coverage.
Judge, we would move this into evidence as defendant's exhibit 2.
The whole big chart.
Yes, sir.
Ricky Fowl, now what is he
Or if
doing?
you like, we can substitute a
Speaking
smaller
of
spreadsheet.
artistes,
Well,
little
I will
artwork.
say it will not
This
fit
is
in
a
my
lot
briefcase.
more art than science here, and Ricky
Yeah, it'll
is
be moved
great
in
with these
without
young
objection,
fans.
I
Make it a
presume.
double.
All right, it'll
Kids
be
may never wash
defense
their
exhibit
foreheads
2.
again.
And in preparing that
Ricky
chart,
Fowl,
how
now what
many
is he
media
doing?
television
Speaking of
clips did you-
artistes, little artwork.
This is a lot more art than science
Oh,
here.
over 50.
and
So every time
Ricky
a
is
website would
great
have
with
a
these young
story, I would
fans.
actually
Make it a
capture that
double.
story, and that's what that is
Kids may
represented
never
there.
wash their foreheads
That was
again.
captured from the websites of the television stations here in the
Ricky
Northeast
Fowl, now
Florida
what is he
market.
doing?
Yes, ma'am.
All right, and how many do you
Speaking
show
of
on this
artistes, little
spreadsheet?
artwork.
75.
This is a lot
And
more
were
art than
those
science here,
The
and
result of
Ricky is
your
great with
monitoring
these
daily
young
for these
fans.
Make it a
in this
double.
case.
Yes, ma'am.
Kids may never wash their foreheads again.
Exhibit 3,
No, that's the same one.
same one.
Ricky Fowl, now what is he doing? Speaking of artistes,
And did
little
you also
artwork.
monitor
This is a
what we
lot
refer
more
to
art
as
than
social media
science
in
here,
Northeast Florida?
and
I did,
Ricky
predominantly
is great
Facebook.
with these young
And
fans.
what did
Make it a
you
double.
find, were there
Kids
Facebook
may never
articles
wash
and
their
mentions
foreheads
about this
again.
case?
Yes, many.
And what did you learn about keeping track of Facebook comments and articles?
Fowl,
How were
now
you
what is
able
he
to do
doing?
that?
The way to
Speaking
do
of
that through
artistes,
Facebook is
little
through
artwork.
certain
This is a lot
keyword
more art
searches,
than science here,
especially pertaining to
and
certain
Ricky
areas.
is
So, for
great with
example,
these
I
young
would do
fans.
searches
Make it a
on, there's a
double.
local Nassau
Kids may
County
never wash their
rant, rate,
foreheads
and
again.
review page where community people post, Nassau County Sheriff's Office Facebook page, Nassau County News,
Ricky Fowl, now what is he
Amelia
doing?
Island newcomers. I mean, anything
Speaking
that
of
had to do with this
artistes, little
area,
art-
and then would do targeted searches that may be related to this case.
And have you also, when you reviewed the television clips on the internet that the TV news stations posted, were you able to see any particular interviews with Sheriff Bill Leeper regarding Mr. McDowell?
Yes, absolutely.
And did you see a clip where Sheriff Leeper invited the public to shoot Mr. McDowell if they saw him in their front yards or at their homes?
Yes, ma'am.
And did you also see a news clip where when Mr. McDowell was taken into custody at the ball field, did you see a news clip where Sheriff Leeper said that he would like to put the needle in the arm of this evil person himself?
I believe he said,
Do you live in Nassau County? Sheriff Leeper.
I do.
And did you work with him professionally when you were a state attorney?
I did.
And you are aware of Sheriff Leeper's past public service in the community?
Yes, ma'am.
And he has been the mayor of Fernandina Beach?
The two-term mayor. Yes, sir. Yes, ma'am.
And he's been a city commissioner?
Yes, ma'am.
And did you work with him when he was in the highway patrol?
I did, because I did vehicular homicides at the state attorney's office, and he was usually the person that was there when I would arrive.
And was he the spokesperson for the state of Florida Highway Patrol here in Northeast Florida?
Yes, ma'am.
And was he on TV often during that time?
Absolutely. Yes, ma'am.
In your personal knowledge and your personal and professional experience, would you say that Sheriff Leeper holds a position of respect in Nassau County?
Most certainly.
And would you say that he is popular among the citizens of Nassau County?
Yes, ma'am.
And was there a news report that also established that Highway 301 had been closed during the time of the search for Mr. McDowell?
There was.
And is Highway 301 a 4-lane road in the Callahan area where this incident occurred?
Yes, ma'am, near Sandy Ford.
And was there a news report that showed that the local high school Friday night football game had been canceled because of the search for Mr. McDowell?
Yes, ma'am.
And was that for 2 high schools here in Nassau County?
Yes, ma'am.
And once again, based on your personal experience having grown up here, would you say that the Friday night football games are a major social event in Nassau County?
Absolutely.
And do you have the television comments that we've discussed here of Sheriff Leeper available for us to view on the computer?
I do. I have all of them, and then 3 that we've discussed here specifically.
And Judge, may the witness step down because she's going to have to come operate the computer if that's possible. I don't think it can be done from that seat.
No, it can't be. Yeah, sure. Okay.
Never enough to do it, I'm sorry.
Sorry.
The one that's pulled up there would be the first one. If you could just play the portion of Sheriff Leeper's comments.
Blow him out the door. Because he's like a rabid animal. He will kill you. His mindset. What he did to that deputy was uncalled for and unnecessary, and he needs to pay for it. So we're going to continue to search. We're going to find him. We're going to find him eventually. We want anybody who has any information to call us, which leads to his arrest. You could be eligible for a reward.
And is there another section of that where he discusses or invites people to shoot Mr. McDowell?
Yes, ma'am. And
This guy is dangerous. If you're in a home, has helped him, or is going to help him, do not do that. If we find out you've helped this guy, we're going to arrest you. We're going to arrest you for preventing us to capture him. This guy is dangerous. If you're in a home and he breaks into your home and you have a gun, blow him out the door. Because he's like a rabid animal. He will kill you. His mindset. What he did to that deputy was uncalled for and unnecessary, and he needs to pay for it. So we're going to continue to search. We're going to find him. We're going
To play the clip that we referred to in your testimony, where Sheriff Leeper spoke about the appropriate penalty for Mr. McDowell.
McDowell shot him twice.
all of our employees live with this every day.
Sheriff Bill Leeper says it's been like a nightmare they can't wake up from. McDowell's first-degree murder charge will go before a jury for sentencing. They'll recommend the court to either sentence a life in prison without parole or death.
He stuck his arm out, pulled that trigger, and took a life. He was brave enough to do that. He should be brave enough to stick his arm out, take that needle of death, and give up a life.
There will be testimony on behalf of McDowell.
And was there a third comment that we discussed about the vote for the death penalty in your, if you could play that link?
It is on Ontario. What about other story?
Okay.
Admitted in court today that he gunned down.
Excuse me, Your Honor.
Ms. Cogan, if it's easier, just play the one that's pulled up next. I'm
Okay.
sorry to go out of order.
Just a second.
God damn this fucking thing.
ethical issue or not.
Just needed to be. Okay. All right, well, apparently we can hear that. So. All right, call your next witness. If you have.
Judge, we would call Sean Vincent.
Board, sir, to be sworn.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, kind of see. Just that microphone if you. Chair is not.
I'll be fine. Thank you, Your Honor.
Would you state and spell your name for the court reporter, please?
My name is Sean Vincent, SHAWN, VINCENT.
What is your occupation?
I'm a litigation consultant.
What do you do as a litigation consultant?
I consult on jury selection and I handle and analyze media for high-profile cases.
How long have you been doing that type of work?
About 12 years.
And do you have clients across the country?
I do.
Do you work in both civil and criminal court?
Yes,
Have you had experience in high-profile criminal cases before in terms of press analysis and jury selection?
I have.
And can you tell the court your experience in those cases?
Sure. Well, I've been involved in high-profile murder cases that had national coverage. I've been involved in local cases, death penalty cases, cases involving law enforcement.
Did our office retain you to prepare an analysis of media articles in the case of State of Florida versus Patrick McDowell?
Yes,
And did we agree to a payment for you?
yes,
We hire you, in other words?
Yes,
We're going to
yes.
pay you. And how much do we pay you for your services?
it was around $5,000.
And do you bill on an hourly basis?
I do,
And does that include the bill for your travel time?
correct,
And you live where?
in Orlando.
And did you prepare an analysis of the media, or, well, did we send you all of the media articles that we collected in the case of State versus McDowell?
Yes.
And what did you review in this case?
So we looked at all those videos, we put them in context, we cross-referenced them with our own search of media online, and we were taking a look at them for geographical scope.
Are you familiar with the media outlets in Northeast Florida?
I am, yes.
And are you aware of the market for the local TV stations based in Jacksonville?
Yes,
Does that market include Nassau County?
it does.
And what about the local newspaper in Jacksonville, the Florida Times-Union?
That is a Jacksonville-based newspaper. It's considered part of the designated media area that's representative of Jacksonville and Nassau County.
Were there media outlets, print media outlets in Nassau County as well that you reviewed articles from?
Yes,
For example, the News Leader,
correct.
and a paper in Callahan.
I can't name the paper, but it sounds correct.
Did you conduct an analysis after reviewing all of those articles?
It,
And did I ask you to prepare an analysis of the penetration inside the viewing or reading market area, including Nassau County, of those articles?
yes,
And let me just ask you to take a look at what's been marked as Exhibit C for identification for the defense. Do you recognize that chart?
I do.
All right, and did you prepare this chart?
I did.
Judge, we would move this into evidence as in defense next exhibit.
No objection, Judge.
All right, it'll be defense 4.
And if you need this to speak from, or if you have it, I believe, on your phone, but I wanted to ask you to
Yeah, that's
explain
fine.
to the court what you found in your analysis of what.
Sure. Well, what we're looking for specifically were the quantity of reports that were local versus reports that were regional and national and international.
And what did you find in terms of the quantity of reports that were local about Mr. McDowell's case?
Well, in particular, what this chart shows is that the vast majority of the reporting on this case has been local reporting.
And were those local reporting sources sources that penetrate the Nassau County viewing or marketing area for local news outlets.
Absolutely.
And you are familiar with those news outlets and their market reach because of your line of work.
Correct.
I don't have any other questions at this witness.
All right, does the state have any questions?
No cross, Your Honor.
All right, thank you. You may step down.
Because my next witness is appearing by Zoom, so I just need to make sure I sent him the link. I have just a brief moment, brief recess.
All right.
May I ask Mr. Smith for that? Looking for Bryan and Edelman. I don't think he's got one. Judge, I'm sorry, I told him I thought it would be more like 3 o'clock, but I'm looking now to see if he's called in.
Okay. Is this your only other witness?
Yes, sir.
Is the state going to be calling any witnesses?
No, sir.
She can't figure it out. So if she doesn't make it come on, but what was going on here is what was going on in the car. I'd be that afraid myself.
Is this going to take a few minutes?
Well, Judge, he has a PowerPoint, so he's ready to log in, but we just have to set the PowerPoint up.
All right, well, I'm going to step down,
That's
allow you to do this without me sitting here watching
Yes,
you
sir.
do that. All
Yes, that's
right.
fine. That I
And,
had actually asked for a short recess. But
that's fine. We'll just take a recess and we'll come right back.
Can you all hear me? All right. Okay. Let me stop sharing for a second.
Mr. Edelman, we're in open court right now. So we're just in a recess.
Okay.
All right, so we're just waiting for the judge to come back. If you're prepared, just let us know if you need another minute to get ready.
I think I'm good. I've got a puppy eating a treat that should keep her quiet for a little bit, and otherwise, I think I'm good.
Okay. All right, so stand by and we'll let the judge know we're ready.
Court is now back in session. All right, everybody have a seat. You can call your next witness.
Judge, we would call Dr. Bryan Edelman. He's on Zoom.
Can you hear us? Dr. Edelman?
Might be muted.
Oh, can you hear me?
Okay.
We can hear you. Can you hear us?
I can hear you very well.
Great. All right, then, Madam Clerk, we're going to need you to somehow, you might want to go to the camera. I don't know, the smart board, you can stand in front of the smart board and administer the oath, okay? Believe we can. There you go.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Thank you, Ken.
Would you please state and spell your name for the court reporter?
Yes, it's Bryan Edelman, BryanEdelman.
And what is your occupation?
I work as a trial consultant.
And what is your business address?
6257 Westover Drive, that's one word, Oakland, California, 94611.
And do you have an entity, a company that you work through or with?
Yes, it's called Trial Innovations.
Right. And what is your educational background?
So I have a bachelor's degree in psychology from Florida State University. I have a PhD in social psychology from the University of Nevada, Reno, and an LLM in international law from University of Kent in the UK, in England.
What does your company do? What types of work does your company do?
So several different things. So in one aspect, we work as traditional trial consultants, which would be things like doing focus groups and mock trials, helping with trial preparation, assisting with jury selection. That would be writing juror questionnaires, writing oral voir dire questions, being present in trial to assist with developing cause challenges and so on. We then also do post-trial interviews, talk to jurors afterwards when a trial is over. And those are more traditional trial consulting aspects. I also work as an expert witness, which I've been doing for a number of years, probably close to 10 or so. And that work started back when I was in grad school with Dr. Edward Bronson, who at the time was the leading scholar in that field. He had worked on Skilling and the Oklahoma City bombing trial, the Boston Marathon case, and a host of others. So I worked with him in grad school and started doing more of that once I got into my own career and profession. And in that capacity, it's more of being an expert. So I'm not so much an advocate, it's more getting retained from either mostly the defense, because change of venue typically is something that only the defense can raise. But I've also been retained by the federal government or the public or the DA to kind of evaluate change of venue motions and that sort of thing. I also work on, so that would be doing telephone surveys, evaluating the nature of the coverage to see if it's extensive, if it's prejudicial, if necessary, if it's appropriate, testifying on whether or not any remedial measures are necessary. And that could be anything from individual sequestered voir dire to more extreme cases where it would be more like a transfer. I also work on post-conviction cases, which is more evaluating the voir dire. Was it effective in cases where there's been a lot of media coverage at ferreting out bias?
And have you previously been hired to conduct assessments or polling of potential jury members in criminal cases?
Yes, I probably have worked close to 100 or been retained on over 100 cases, high-profile cases, to make that determination in both federal and state cases around the country.
And have you handled any type of assessment of potential jury members in any cases in Florida?
I have. Off the top of my head, I worked on the Parkland shooting case, which was Broward County. In a federal case would be Aaron Zahn, which is the former CEO of the JEA in Jacksonville. This one, and that might be it. I'm not sure. I'd have to look back and see for others.
Okay. And how did your educational background and training prepare you to do that line of work?
So the program I went to focused on social psychology and jury decision making. I went to the University of Nevada, Reno, because there were a lot of professors at the time that focused on that. The National Judicial College is based in Reno. There's something called the Grant Sawyer Center for Justice Studies. So that's why I went there. And I worked under a professor named Ronald Dillahay, who did that type of work. And then I also worked with Edward Bronson, as I mentioned. At the time, my interest was in jury decision-making relative to the death penalty. So that's where the focus of my dissertation and research was, particularly in interracial cases where you see more of a race to victim effect. So murders of African Americans are more likely to be sentenced to death than murders of Caucasians. So I was interested in how race influences jurors, and published a book on that when I was finished with my studies. But yeah, so, and we also focused on research on voir dire as a remedy or tool for ferreting out bias in high-profile cases. That's what I was interested in, is something called minimization language, which essentially, when you ask somebody what have they read, seen, or heard about a case, when they've been exposed to media coverage, they'll say things like, "I just remember when it was in the paper," or "I only saw it when it first happened," something like that. But if you probe more, it turns out they actually have quite a bit more knowledge than they initially indicate. And my interest was more in the difference between recall memory versus recognition. So recall is kind of something like, tell me everything you know about the movie Star Wars, and you would tell me a whole bunch of things, but you'd probably miss some things that you actually do know. Versus recognition are probing questions like, did you know that Darth Vader was Luke Skywalker's father? You'd say, oh yeah, I knew that too. So the challenge is in high profile cases or media, you can't ask those type of probing cases because you could be poisoning the well if the juror doesn't know that prejudicial fact. So it kind of...
Let me just stop you there and ask you, if you wouldn't mind, go back and spell the names of your two professors, please, for the court reporter.
Sure. It was Ronald, R-O-N-A-L-D, Dillahay, D-I-L-L-E-H-A-Y, and then Edward, E-D-W-A-R-D, Bronson, B-R-O-N-S-O-N. He was at the University of Chico.
And can you generally just describe the process that you use to assess potential jurors in a community to determine whether they have been influenced in any way, or whether media has had a role in any advance opinion that those potential jurors may have?
Yeah, so I go through a 3-stage process, and this is something that Dr. Bronson had taught me. So the first phase typically It's just collecting the media coverage and making an assessment if there's extensive or prejudicial coverage. And that's just, so collecting all the coverage, the local newspaper coverage, reviewing it, and identifying, does it have things like inadmissible content, sensational elements, is it highly prejudicial or detailed? Is it extensive? That sort of thing, to make an assessment if it even merits going forward. Because sometimes I get calls on these cases and it's like 5 articles 3 years ago, and there's really no justification for going forward at that point. If it looks like there's potentially extensive prejudicial coverage and there's a risk that it may have had an impact on the jury pool, we would recommend potentially going to phase 2, which would be a community attitude survey to make an assessment if the coverage has actually had any impact on the jury pool. And there you're really trying to measure, what is the recognition rate in the community? How many people have read, seen, or heard about the case? Have they developed any opinions? That could be towards guilt, it could be towards sentence, it just depends on the nature of the case. Are those strong fixed opinions? So I'm really interested in, has the presumption of innocence shifted to a presumption of guilt? Do they know a lot of case specific media items that were reported in the coverage? So they have extensive case knowledge, simply because we know that case specific attitudes are predictive of behavior. So we want to know, do they know a lot of detail? And then from that analysis, we make an assessment whether or not there are any remedial measures are necessary. So sometimes it's that middle ground where there's coverage, it was extensive, there's a high recognition rate, but it's not overwhelming. Maybe it's like 50% in a large community. So we would recommend things like individual sequestered voir dire or an extensive juror questionnaire, maybe extra peremptory challenges, things like that, versus more extreme cases where there's a lot of case recognition and strong prejudgment is very high. And then we might recommend a more, significant measure like a change of venue or transfer to, if it's federal, to a different division within the district or something like that.
All right. And were you retained by the Office of the Public Defender to conduct such a community attitude survey in the case of State of Florida versus Patrick McDowell?
I was.
Okay. And in Patrick McDowell's case, were you advised that the question was not whether there was media penetration about whether he was guilty or not, because he had already entered a plea of guilty?
Correct. Yes.
Right. And what did you learn? What information did you gather, and what materials did you review to prepare for your community attitude survey and assessment in this case?
Yes. So I collected the media coverage in the Florida Times, Union, was it the Nassau County Record, and I believe the News Leader. And I found about 92 articles about the case. So I reviewed all those initially. One is to write the survey and base it off of the media coverage. So like using the language from the coverage to develop the recognition question, the media items, and all those sorts of things. And every case is different, so there might be unique elements. So I've done a lot of cases involving the killing of a police officer, so I know some of the elements to include are things more about community impact, how the community rallied, and things like that. And that was similar to this case. I've also done on the opposite side of the spectrum a lot of cases where a police officer is the defendant, and then it's very different what you're covering, because a lot of times in those cases it's anger investigations into excessive force or things like that that might be going on as far as into the police force and things. So it just depends on the case.
And what is the process after you review all of that material and get information about the case? What did you then do in Mr. McDowell's case?
From that, I drafted the survey instrument, and I have a telephone survey vendor that I use, and they administered the survey, and we collected, I believe, like 200 completes in the county, and fielded the survey. And once the data were collected, I analyzed it and made an assessment about whether or not there had been community judgment or prejudgment, high case recognition.
And when you say the survey instrument, you draft the script. Why do you draft the script for the people who conduct the actual telephone surveys?
I'm trying to watch you there. Why would I draft the script as opposed to what?
Why do you do that for the people making the calls? Is there a protocol that you do that rather than?
As opposed to whom? Who?
Anybody but you.
Oh, okay. Yeah. Well, one is I've taken coursework in how to draft surveys and all the things you need to look out for, from order effects and response bias and all those things. I'm following their standards and guidelines established by the American Society of Trial Consultants of how to draft change of venue surveys. It's based off of my own experience working with Ed Bronson, doing hundreds of these, and so on. So I certainly wouldn't hand that off to just anybody. And I wouldn't want, for example, my client's office to do it because they have their own biases of what they want to put in the survey, and they might be leading questions, they might not be appropriate. So that's not something I would be comfortable with. Again, like I take this role very seriously. When I'm doing trial consulting, I'm an advocate. When I'm doing this, that's not the case. I try to be more of an objective expert, and I think that's very important.
And when you set up the script, in this case, for a contract company to make phone calls and read the script to people who answer the telephone, did you follow the industry standard in drafting your script?
Absolutely.
And did you prepare the script to have the best possible outcome in terms of the needs of this survey?
I prepare the script to create a reliable, valid survey instrument so that I can make generalized to the population of interest. I don't write it to have a quote outcome. The outcome is whatever the data indicate.
All right. And is it important that the script itself not contain an outcome for the answers of the questions, the answers to the questions?
Absolutely. I would never, for example, in a recognition question, include something like you mentioned earlier, the defendant confessed to the crime or pled guilty. I would not put that in the recognition item because although it doesn't, in this case, it doesn't matter, but there's a guilt question following it. And if you included that, you're guaranteed to have a very high rate of guilt because you just told the respondents that he pled guilty. So you have to be very tactical and careful what you put in your questions so that it doesn't create response bias to later questions.
And what company do you hire to do the actual telephone calling, and how does that work?
So I've been using one based in Alabama called Research Strategies, and I've used them for years. They've done many of these surveys for me. They follow all the standards in terms of they pull their sample so it's a random sample of the community. They make calls on different days of the week, including weekends and weekdays and different times of the day. They work a small piece of the sample, so they have to call each number 3 times to get a disposition code, before they move on to the next number, all the things to try to work on improved response rates and so on.
And is that to ensure the credibility of the results of the polling or the community attitude survey?
Yeah, not so much credibility, it's more reliability and validity. You want to make sure there's no quote response bias. You're not underrepresenting important groups that may be related to the outcome of interest, things like that. So you do your best to adhere to the standards so that you can generalize to your population of interest, which in this case is to prospective jurors.
And when was the telephone polling conducted in this case?
I would have to look at the report. I don't remember the exact dates in terms of when it was in the field.
Was it in the last 2 or 3 months?
Yeah, something like that. Yeah.
All right. And were you confident in the reliability of the results of the community assessment survey conducted by telephone?
Yes.
And can you explain those results to us? And I believe you have a PowerPoint.
Yeah, it'd be easier if we can kind of go off that instead of top of my head, but okay if I share that?
Yes, you may, if that's acceptable with the court.
It's fine.
Okay. All right, give me 1 second here. Okay, so let me jump ahead. It's okay if we start here? So this is basically just a breakdown. I focused on 3 areas. One is just giving a little background of what we know from the social science literature on the impact of pretrial publicity on juror decision-making. The second section focuses on the findings of the community attitude survey. And the last section talks about trying to complete jury selection in a case like this to identify and ferret out bias, given the findings in the study. Okay. So there's been about 40 years of research on the impact of pretrial publicity on jury decision-making. And there's 2 types. There's field research, which is conducting community attitude surveys So it's naturally occurring pretrial publicity and natural exposure, however people consume that content. And it allows us to see if that coverage has any impact on pretrial verdicts. It doesn't allow us to do things like learn more about how it affects decision making and how group dynamics comes in and so on. So we look at experimental research to do that. And that gives us more insight into a controlled study. We could identify the types of pretrial publicity that are most impactful, how it influences juror decision making, and so on. So without going into too much detail, it's just a few examples of what would be some of the field research findings. In some instances, how we test the reliability of our findings. So this was just one study. And in this case, they looked at 3 change of venue surveys. One was the killing of 2 police officers in Nassau County. One was the murder of a dental hygienist from a prominent family in a small community. And then there was a sexual assault case. And what they found early on was that media habits, how we consume media, impacts case knowledge. And this is one of the things we test in our survey. So people that regularly watch the news, regularly read the newspaper, are more likely to know about the case, and they're more likely to be familiar with some of the items reported in the media, and that's case knowledge. And then we also know that case knowledge impacts perceptions of guilt. So the more people know about the case, the more likely they are to believe that a defendant is guilty. And they found that case knowledge is 10 times more important than attitudes towards crime, gender, education, and a host of other things. So the most important thing that they found from this study was that case knowledge was more impactful on views towards guilt than any of these other pre-existing things, such as, again, age, education, criminal justice attitudes, and so on. Now, some of the experimental research is more, again, done in a lab. And what they find is that exposure to pretrial publicity impacts perception of guilt. So we know that, and they learn like what types of pretrial publicity are most effective or impactful, and it's character type evidence, so the defendant's character, and emotional pretrial publicity. For example, the community outpouring of support, positive content about the victim, and so on, are more impactful types of pretrial publicity. And the way it works is it influences how jurors view the defendant's credibility, likability, and sympathy. And from my experience working on capital cases and kind of doing research on this, that's quite important simply because empathy towards the victim has been shown to impact how jurors evaluate mitigating evidence in capital cases. And that type of impact is more significant when you have kind of ambiguous aggravators, maybe something like it was a cruel and heinous crime. Jurors don't really quite know how to define that, so they look for other things. It could be victim impact statements and so on, but attitudes, empathy towards the victim has an impact on how they view that. And they found that judicial remedies such as jury instructions, voir dire, don't eliminate the pretrial publicity effects. This is just one study to kind of give you, again, insight into how this work is done. So in this one, what they did was they recruited prospective jurors at the courthouse, and they recruited them to participate in the study, and they read one of 2 types of articles. One type included prejudicial pretrial publicity that was inadmissible. So it had criminal background information and a retracted confession. And then the control group didn't have any of those inadmissible facts. And then they listened to a murder trial, and what they found was that 72% of participants exposed to negative pretrial publicity, that's the prior conviction and the retracted confession, voted to convict, compared to just 44% who had not seen that type of pretrial publicity. And this was a significant finding. And then really learning more about how pretrial publicity influences decision making. And this is kind of where the research has gone recently, because it's pretty well established that it does. So what we know is media coverage simply impacts how we process new information. And that's not really novel. It's kind of how our attitudes affect us all the time, how we see the world, how we live in the world. So it results in selective perceptions of evidence. So if you've developed strong opinions based off of case-specific media coverage, you develop strong views. It could be impressions of the defendant, impressions of the victim, so on, the evidence. And you filter new information, or when you're a juror, new evidence through that lens. And we tend to spend more time focusing and processing information that's consistent with how we see the world. So that's a confirmation bias. And we try to ignore or refute things that are inconsistent. Sometimes it's called the perseverance effect, where we find if you develop an attitude, you're more likely to believe that view, and if you're provided with inconsistent or conflicting information that undermines that attitude, you work hard to refute it. So this again is another study. This was Hope and Memon and McGeorge. And what they did was they had people read some negative pretrial publicity and waited several days. And they watched a video of the murder trial. And they measured the effects of media coverage. And what they found was that there was this thing called pre-decisional distortion. So if you had read negative media coverage and you thought you were pro-conviction, at each phase of the murder trial, people interpreted evidence to be more consistent with their leader, meaning like the government versus the defendant. And they found that negative pretrial publicity had a higher prosecution score than the control group. So again, like if you saw the negative coverage, you're more likely to interpret evidence to be consistent with that worldview that you hold about the case. And the other interesting thing here is, so this was a similar study, but what they found was after they did this, so they had participants review media coverage and wait 5 days, and then they watched a murder trial, and they found that people who had seen the negative media coverage were twice as likely to vote to convict as those who had not seen that coverage. And then they waited several days and brought them back, and they asked them, they gave them different pieces of evidence. Some of it was in trial, and some of it was in the media coverage. And they asked them where they had learned that particular piece of information. And over time, jurors forgot where it came from. They forgot the source. So they misattributed media coverage to trial evidence. So that was a concern. So when we asked jurors if they can set aside what they've read, seen, or heard about a case, part of that is knowing where that information came from. And it becomes ambiguous and you think it was in the trial, that's problematic. And it's also problematic when it was both in the media coverage and in the trial, because it's just confirming what you already know. Okay, so moving on, why don't we jump into what we learned from the community attitude survey. So this was kind of the way the survey is structured. So it's a random digit dial telephone survey. The first section makes sure that the participant is eligible to be a juror. So they have to, for example, have a driver's license with a Nassau County address on it, or have an ID with an address on it to be 18 and over, and so on. So they have to be jury eligible. The second phase asks different general attitude questions towards the criminal justice system, local police department, things like that, just to get people comfortable with the process. It shows that the survey is about the thing they think it is. It's about a particular case. It's not about selling you anything or something like that. And then the next section are the key areas. And this is case awareness. And also some media habits, like how often do they read the paper? How often do they read, and so on. And this is just a high-level chart of the findings. So the first column tells you what percentage of prospective jurors fall into a category, and then a scenario. If you called 100 jurors for jury duty, what would you expect to see in that panel? So 85% of prospective jurors in Nassau County, based on the survey findings, have read, seen, or heard about the case. Of that group, 83% believe that the defendant is guilty of murder. There's strong views, which you'd expect given one, what they've seen, two, that he's already pled guilty, but 57% think he's definitely guilty. Half the group who know about the case believe he should be sentenced to death, compared to just 23% who support a life sentence in this case. And our fixed opinion question is, given what you've read, seen, or have heard about the case, would the defendant have a difficult time convincing you that he should receive a life sentence instead of the death sentence? And you can see it's quite high for those that don't that support death or something else. 56% answer that question in the affirmative. And then 64% have a negative opinion of the defendant. And that's important because, as I mentioned earlier, the research shows views towards the defendant, which kind of goes to future dangerousness and all those types of things that come into play for sentence are quite important. And going into trial, they already have developed this negative impression based off of media coverage. So if you looked at 100 jurors that you called for jury selection and they came in the room, you'd expect 85 of them would know about the case. 71 of that 100 would think that the defendant's guilty of murder. 48 would say definitely guilty. 43 would favor the death penalty. 20 life. 48 would basically tell you that they have strong fixed opinions, almost half the group, and 54 already have negative to very negative opinions of McDowell. Looking at the actual other elements like case knowledge, you can see like people in the community know a lot of detail. It's not just passing knowledge. You know, I remember hearing about, I don't know much. When you ask those, have you read, seen, or heard if questions, 76% recognize at least 3 of the media items we tested. For example, have you read, seen, or heard if there was an outpouring of support for Deputy Moyers and his family after he died? 92% knew about that. Have you read, seen, or heard if Patrick McDowell shot a police dog during the search for him? 67% knew that. And then 28% had some direct or indirect connection to Officer Moyers and his family, or people actually knew, or people who knew him. So high, given the circumstances. And again, that just gives you, of the 100 jurors, what you'd expect. So 65 of them would know at least 3 of the items. So a lot of case knowledge. 78 would know that there was a huge outpouring of public support. 57 knew that he had shot a police dog during the search, and 24 would know, have some direct or indirect connection to Officer Moyers or his family. And really the thing that stood out to me was that this case really captured the community's attention, and just, it's really seared on the public's consciousness. So one, people talked about it a lot. So 54% of prospective jurors who recognize the case have already talked about it. So almost half. And that's where rumors get spread. That's where misinformation is spread, is what we call the informal communication network. So that's pretty significant. And 62% have heard others talking about it online. And in looking at those 2 questions, 70% of respondents have either talked about the case or heard others talking about the case. So it's definitely was a significant event in Nassau County, as you'd expect. And 50% of jurors who recognize the case believe that Patrick McDowell should receive the death penalty, and that's more than twice the amount that support a life sentence. So 50% support death, and just 23% support life. And part of that was interesting is the, well, here you can see it. These are strong fixed opinions. So 56% reported that those who you would have a difficult time convincing them that he should receive a life sentence instead of the death penalty. So it's really putting the burden of proof on the defendant to change opinions, to change minds. Sometimes, like when it's a guilt question, it's a presumption of innocence. This is a presumption of death, where now the burden is on the defense to persuade jurors that he should receive a life, and they're telling you that would be a difficult thing to do. So that's quite high. And I think part of that is tied to, if you read one of the things we have in the survey, are open-ended questions about how the community was affected by this crime. And there's some really strong responses in terms of, you know, people saw, for example, they came together for him. He was a good person. He was respected by the community. The community took it hard. Everyone had a hard time in Nassau County. He was a wonderful officer, given how people, the way they did. I remember it was a huge deal. It was sad. I live across from the cemetery he was buried at, and he had tons of flowers and stuff. People still go there and put stuff out there. I work in a restaurant in Hillard, and when his funeral procession went through, I don't think I've ever seen a funeral procession as long as his. He actually died on my birthday. All came together, fundraisers, T-shirts, brought all the community together. It was huge how they came together. We all stood at the highway as he was driven by, hearts broken, angry, and wanting justice. They came out to honor him. People were writing stuff on their cars for him and leaving messages all around town. They raised money and stuff for his family. They put up a billboard and stood around the family. They did a banquet and rallied around the family. There's an outpouring from all aspects of the community, lots of vigils around the county, remembrances and parades since his death, a big outpouring as I would describe it. I think everybody in the county was shocked, devastated, and on lockdown and brokenhearted. I locked my son down to keep him safe. He killed a police officer. So there's quite a few of those. And it just shows that this was a horrible event in Nassau County. It really shocked the community, and people followed it pretty closely. It's kind of seared in the public's consciousness. So one of the things we do is we measure case knowledge, and that kind of goes back to the social science literature. And we want to know, do people just have a passing familiarity with the case, or are they familiar with a lot of detail? So we measured, in this case, 7 items that were published in the media to see if people knew about it. And what we found is people had a lot of case-specific knowledge. So you can see 76% knew at least 3 of those items and 56% knew 4 or more. So people followed the case, they remembered the details, even though there's been, with the passage of time. And survey respondents exposed to coverage have developed negative opinions of the defendant. So 54% reported that they had very negative opinions of Patrick McDowell, and 64% overall had negative opinions, or 67%. So quite a large number of people have developed negative opinions, and they're not just slightly negative, they're pretty strong. And those negative opinions were impacted by exposure to media coverage. So it's not just in general, they just have negative opinions of criminals or people accused of murder. You can see it's tied to case knowledge. So the more people knew, the stronger their opinions were. So if you knew 4 or more media items, 62% of that group reported very negative opinions of the defendant. So as you'd expect, the more media exposure you have, the more likely you develop negative impressions of the defendant. And those matter because they're related to sentence. So if you have a negative opinion of the defendant, just like in the research and in the literature, you're more likely to support the death penalty. And in this case, you can see those who had a very negative opinion of the defendant, 69% of them support the death penalty compared to just 15% support life. So again, kind of taking a step back, media exposure develops case-specific knowledge. Case-specific knowledge is tied to impressions of the defendant, and those impressions are tied to views towards the appropriate sentence in this case. And again, those negative opinions also are tied to fixed opinions. So these are strongly held beliefs. You can see those who have very negative opinions reported that the defendant would have a difficult time convincing them that he should receive life instead of death. So 72% of those individuals, quite high. Okay. So the last section here is really the idea about why can't we just try to pick a jury and see what happens. And in most cases, that's fine. We've all picked juries before. And in general, when you have a case and people have general attitudes, you can ferret out that type of bias. And general attitudes are not as predictive as behavior. There's a lot of research on this. So if I have a general view towards exercise, that doesn't mean that's predictive of me going for a run today. However, specific attitudes are more predictive. So if I have a specific attitude towards jogging, that is much more predictive of whether or not I'm going to go for a run today. And it's the same thing here. So when jurors have general views towards like DUI or that kind of thing, that doesn't mean that they can't serve on any case involving a DUI because they don't know the specific facts of the case. They're not strongly held beliefs. But when you develop case-specific knowledge about this specific case, those attitudes and views are predictive. So it's really important to be able to ferret out what jurors know so that you can identify jurors that can't be fair and impartial. And sometimes we know jurors will say they can be fair and impartial, but you have to have all the information so that you can make an assessment rather than just take that at face value. And there's specific challenges that are posed in high profile cases. One, difficulty uncovering the full extent of what jurors know. We know how easy it is to rehabilitate jurors who profess they can't be fair. There's a well-established social desirability effect, and we've all seen that in civil and criminal cases. And just the realities of the voir dire process in high-profile cases. So there's a lot of research on honest disclosure. One study conducted by someone named Seltzer, Seltzer, and what he did was he watched 30 criminal cases, and it was like 130 jurors. And the questions he focused on whether or not they'd been victim of crime and whether or not they were connected to anyone in law enforcement. So they tracked the answers. And at the end of each trial, they interviewed those jurors and asked those same 2 questions, same exact questions, but in private. So it's not in a group setting. It's not with the court reporter and all the pressure. And they found that 25% of jurors gave a different answer on whether or not they'd been a victim of crime. Turned out 25% now said yes. And 30% indicated that they had a connection to law enforcement that had not reported that during voir dire. And looking at those 2 questions combined, it was a total of 39%. So 39% of jurors gave different answers. And I've seen this in cases I've worked on where it's post-conviction or post-trial and reviewing voir dire transcripts and seeing jurors who don't report that they've been victims of crime, and it turns out they've been kidnapped and held at gunpoint, left in the desert, and all these specific things that come out later. Judge Moyers is another example. He conducted a study in Washington, D.C., where he did group voir dire on 30 cases, and then he brought back all the silent jurors in the chambers. It was about 28% of each panel he called silent jurors because they didn't answer any of the questions. And he asked them in private, is there anything you would want to tell me? Because I noticed you didn't answer yes, you didn't raise your hand, you didn't answer any question. And he found that in 28 out of those 30 cases, at least one juror gave a new answer that led to a cause challenge. And the examples were things like, I'm the defendant's fiance. I'm connected to law enforcement. The defendant is in my church. All these things that they don't share in public because there's anxiety and all these hosts of issues when we do group voir dire of why people don't talk. So this is a real phenomenon that we need to look at. So that's the first problem in a case like this. And then we have a bigger dilemma, which is the recall versus recognition. So recall is the only thing you can really do in voir dire, and that's when we ask on the questionnaire or we ask in voir dire, tell me what you've read, seen, or heard about the case. That's a recall question versus have you read, seen, or heard if, for example, the defendant pled guilty. That's a recognition item. And memory, they're both different memory items, and one is much more difficult than the other. So recall is a much harder memory task than recognition. And this became a prominent thing for me because I was working on a case in Texas. It was John Feet, and he was a Catholic priest who had been charged with murdering a beauty queen in the 1950s, and many decades had gone by, and he was being tried for this case. It was very prominent at the time in Hidalgo County, southern Texas. And there, what we had to do was bring people into the community members and ask them if they thought the defendant could get a fair trial and so on. That's just part of the process in that county that we had to go through. And we asked them, what have you read, seen, or heard about the case? And they told us, I know it was a priest, it was a very big deal, he murdered a beauty queen and so on. And we asked, is that everything you know? And they say, yes, that's everything. And then we'd ask, well, have you read, seen, or heard if he confessed to the crime? Well, that's something you could never ask in real voir dire, and it triggered a memory for them. And they'd say, oh, that's right. He actually confessed in a monastery twice to a different priest. And then asked again, is that everything you know? And say, yeah, that's all I remember. And then we'd ask, well, have you read, seen, or heard if he was ever charged with attacking anybody else? And they'd say, oh, that's right. In the neighboring community, he attacked a woman in church as well. And it just went on and on like that. There was a conspiracy to cover it up, and everybody would know that if you asked a recognition question, but they couldn't recall it from memory when you asked the open-ended question. So that is probably one of the biggest problems with voir dire in high-profile cases is you can't fully identify what they know about the case, because we know that people minimize what they recall and they struggle with memory, just kind of like my Star Wars example earlier. And you can't ask those probing questions because you can be poisoning the well. You're telling them information that they don't know. So now what are you supposed to do? You just gave that juror highly prejudicial information if you didn't know about it. And we do.
Can we stop? Right? I mean, it's now become a lecture, not a question and answer or direct examination. And our court reporter, I think, needs a little bit of time to rest her fingers.
I'm sorry about that.
I just had asked him the methodology of the survey, and so he was going.
That we got way beyond the methodology. Whole survey.
So, Dr. Edelman, let me just ask you this question first. Did the script include any identifying factors that you had been hired by the counsel for Mr. McDowell?
What do you mean by identifying factors?
Did you tell the people that you were talking to, or did your telephone callers say, we work for Mr. McDowell's lawyers?
Absolutely not.
Right. And would that violate the industry standards in conducting the community assessment survey?
Yes, I would expect people in the community who, if you tell them I'm working for the defendant, they're probably more likely to either hang up on you if that case is an important case in the community, or misrepresent findings or whatever it be. So you never tell the source of who's sponsoring the survey.
Right. And overall, what were your conclusions regarding the media impact on the potential venery in Nassau County?
As I mentioned earlier, clearly there is a significant impact. Over 85% have read, seen, or heard about the case. Jurors recognize case-specific facts. Over 50% of the group think that he should receive the death penalty. Over 50% reported strong fixed opinions that you'd have a difficult time convincing them otherwise. And the survey data support what we know in the research literature. So The more knowledge you have is tied to media exposure. The more knowledge you have leads to case-specific attitudes towards the defendant. Those attitudes are significantly related to sentence. So shows the reliability and validity of the findings because it's consistent with the findings in the social science research.
And is it fair to say that not only the media penetration of the potential jury pool, but the word of mouth or the knowledge passed between individuals or families or interactions in the community also can affect the potential jury pool?
Absolutely. That's the informal communication network in small communities where people talk about it, they pass information. So it's not just watching the news or reading it, it's what your friends tell you, your family tell you, what you talk about at work, all those types of things. And it was quite high in this case.
And are you able to give an opinion based on the results of your community attitudes survey and the polling and the facts of this case as to whether there's whether we'll be able to obtain a jury from the Nassau County pool that would be fair and open to the facts of this case and the penalty phase for Mr. McDowell?
I can never say there's no way in the world you can't find 12 people that would profess fairness, that they can be fair and impartial and set aside their bias, because I think you could do that in any case, no matter how horrible the venue is. But I don't think that's, from my perspective, that's not what I do. My focus is on whether or not there's a high risk that the defendant's fair trial rights have been undermined, and I think they have. I think there's a high risk that you will have jurors with strong opinions. And I don't believe, from my experience in cases like this, that voir dire is an effective remedy when you have strong views, high recognition rate, and so on, which is kind of what I was talking about here.
Okay. And so it's your opinion that because of the high recognition rates, it would be difficult for him to have a fair and impartial juror sitting in his penalty phase?
It's my opinion that based off of the case-specific knowledge people have, the strong negative impressions of the defendant, and the inability or the challenges in identifying which jurors know prejudicial content, for example, comments the sheriff made in the community about what the appropriate sentence is, because that's in the survey and over 20-something% knew that, but only one person mentioned it in the open. I don't think voir dire is a reliable remedy for ferreting out that type of bias.
And Dr. Edelman, let me just show you what I've marked for identification as Defendant's Exhibit D. Can you see this? Are you able to see this?
I cannot see that. You got to put it towards. I can see it, but I can't read what it is. I don't know what that is.
It says on the cover, trial innovations, telephone survey results, descriptive statistics, state of Florida versus Patrick McDowell, prepared by Bryan Edelman, PhD, February 27th, 2024.
Your Honor, we will stipulate the authenticity of the survey results that were provided to us in discovery.
All right.
That to the evidence of defendant's next exhibit.
I believe it states 5. Is that correct, Madam Clerk?
Defense. 5. Yes. Okay, thank you. I don't have any other questions, Your Honor.
All right, does the state have any questions?
Yes, sir. Good afternoon, sir.
Good afternoon. How you doing?
I am doing well. Previously in your direct examination, you had said that in extreme cases, you would make a recommendation that transfer or a change of venue would be appropriate, correct?
Yes.
And when you were discussing cases that you had worked on, one of the cases, Parkland case, correct?
Yes.
And did you work for the defense on the Parkland case?
I did.
And did you reach an expert opinion that in that case, the defendant couldn't receive a fair trial?
No, I didn't.
You did not, you did not?
I didn't. I don't think they even pursued a change of venue in that case.
Okay. You did also recommend or you worked on the JA case as well. I think you recently talked about that. And did you recommend the change of venue in the JA case?
Yes, a transfer. So a little different within the district.
Correct. It's a different standard in federal court versus state court. And so you recommended a transfer in that particular case because of the predominance of the media publicity in that case, correct?
Well, the case specific there was, it was one particular piece of knowledge where statements he made that were highly prejudicial and potentially inadmissible. The worry was that jurors don't identify that they know that detail. So voir dire would be the issue in that case.
In going through your study just briefly, on page 3, you discuss general attitudes towards the criminal justice system, and only 16.5% of the people actually answered out of the 200 surveyed that if the government brings somebody to trial, that person is probably guilty. Is that accurate?
I don't have it in front of me, but yeah. Well, let me pull it up real quick, see if I can see it, if that's okay.
I believe it's page 3 of your survey that was just moved into evidence.
Okay, let me just open it real quick so I can follow you. Okay, page 3. Right, and which question number is it? Question 1A?
If
Yes.
the government brings somebody to trial, that person is probably guilty, only 16.5% of the people answered affirmatively to that.
Yes.
Okay. Wouldn't you agree that's a very low number?
You'd be surprised. I think this changed over time, but yeah, I've seen that quite a bit.
Okay. And moving on to the next page of that document, when you question whether or not individuals of the 200, and let's be clear, these are 200 potential or prospective jurors who were questioned by the survey, correct?
Right, yeah, jury eligible community members, yeah.
And that was the point. They contacted jury eligible people. If you weren't eligible for jury selection, they wouldn't have been called.
Well, I mean, you would screen them out. You can't identify the random numbers.
Okay. But out of that group, 82.5% of the people answered that they had never worked for the Nassau County Sheriff's Office or had any connection with the Nassau County Sheriff's Office.
Right.
And when this survey was conducted, the defendant had already pled guilty, correct?
Yes.
Okay. But despite that fact, that guilt wasn't an issue, you still questioned about guilt.
Absolutely, because it doesn't mean everybody knows that he pled guilty.
And even though the defendant had already pled guilty, only 82.8% of the people actually thought he might be guilty, despite the fact that he'd already pled guilty in open court, and he's presumed guilty at that point.
Well, I don't think 100% of survey respondents knew that he pled guilty. I think it was only 10%.
Okay. So that also goes, though, to the saturation level of the publicity in regards to the trial, that not everybody who you questioned out of these 200 people even knew he pled guilty to the offense.
That specific item, that's right.
And moving on to page 7 as to whether or not a sentence, 55.7% of the people stated they would have a difficult time imposing a sentence other than death, correct?
56%, let's say, right.
Approximately 56%.
Yeah, and to be clear, the people in that group are those, it would be, yeah, you got it. Okay.
But at the time when you're answering this question, these people don't have access to the facts. They are not instructed on the law. They don't even know what mitigation and aggravation is when they are making the statement to you.
Of course not. I mean, we're not measuring outcome. That's not the standard for venue. We're not, it's whether or not people come in with preconceived notions at the start of trial and you have to change their mind. It's not, what will they do as a juror as a member of the jury and deliberating as a group and being instructed. That's certainly not the standard or what I'm looking at.
Okay. When you talked about level of awareness, 85% of the people had heard that he'd been captured, correct?
Captured? Yes, it was. Give me the question number so I just can follow you. What do you mean by captured? I don't think that was a question. I think it was whether or not he'd been captured in front of the Little League concession stand. Is that
correct?
Okay,
yeah. On page 8, 85% of the people were aware that he was apprehended.
Yes, in front of the concession stand after 4 days after he shot Officer Moyers.
And I think he already stated this, only 10% of the people were even aware that he pled guilty.
Correct.
66.9% of the people were unaware of the statements that were made by Sheriff Leeper that were part of the discussions that we have been having previously in this hearing today.
Was that question 12?
On page 10.
Right.
That's accurate, correct? 66.9
That's an yeah,
were unaware of the statements that were made by Sheriff Leeper.
correct.
72.8% of the people had never seen the video of the murder.
Sure, yes, correct.
73.4% did not support law enforcement during the course of the search for the suspect while he was at large.
Correct.
And nearly 70% of the people who were questioned in this 200 pool of prospective jurors had no connection to the victim or the victim's family whatsoever.
Yes, that's right.
Thank you. I don't have any further questions.
All right, any redirect?
Yes, thank you. Dr. Edelman, the purpose of the survey is to determine whether jurors can come into the courtroom with an open mind to be instructed and to follow the instructions given in the courtroom without a preconceived notion. Is that correct? To find if that's a problem.
The purpose of the survey is to identify what percentage of the jury pool knows about the case, harbors bias towards the defendant, and has prejudicial case-specific knowledge, and whether or not, which was kind of the end I was trying to get to, when you ask them, what have you read, seen, or heard about the case, do they identify highly prejudicial comments or information they might have? So when you mention Sheriff Leeper's comments about sentence, which is highly prejudicial, that he should be executed, 20-something% know about that. But nobody mentions it when in voir dire when you say, tell me everything you know about the case. So how are you supposed to know who knows that highly prejudicial fact if they're not able to access it? And you can't say, raise your hand if any of you jurors know that the sheriff said he should get the death penalty, because now you're poisoning the well. So that's part of what the survey is trying to identify is what percentage of the jury pool knows about the case, what types of case knowledge do they have strong opinions about guilt or sentence, and are they able to effectively disclose all that information when you ask them open-ended as in voir dire?
And does your survey establish that the likelihood of obtaining a jury pool, of having a jury pool in Nassau County come to the courtroom without a strong fixed opinion about the sentence of death for Mr. McDowell, does your survey address that?
Yes, it does.
What is the likelihood, based on your opinion, that a jury pool can be selected, can be gathered that does not have a strong fixed opinion that Patrick McDowell should receive the death penalty?
My opinion is the veneer and panel, based off of the master wheel, is likely to come into the courtroom where a large percent of those jurors have strong fixed opinions about what the appropriate sentence should be based off of case-specific knowledge. And that poses a significant threat to the defendant's due process rights, and a risk that jurors will be listening to evidence that confirms what they already know and think and believe.
All right, thank you. I don't have any other questions.
All right, you are excused, sir.
Thank you very much.
All right. Does the defense have any other witnesses or evidence to present?
None from the defense, Your Honor.
State have any witnesses or evidence to present?
No, sir.
No motion.
Yeah, thank you though.
Judge, I know often we always say, let's wait and see if we can select a jury. But in this case, given the inordinate amount of public awareness and strong fixed opinion about a death sentence for Mr. McDowell, coupled with the fact that we have more than 40 witnesses who are out of state, out of the country, that we have to make travel arrangements for. Ordinarily, we would say, let's wait and try to select a jury. But in this case, the facts are so egregious and the logistics of this trial are so I guess, large, require so much for planning and so much so many travel arrangements and so much cost to the public defender's office that we believe it's just better to go ahead and rule on the motion for venue change without trying to get a jury, just because of the possibility of the logistics. The Supreme Court of Florida has held that obviously the ruling for on a change of venue application is in the sound discretion of the trial court. We have the burden of coming forward and showing that the setting of the trial is inherently prejudicial. I believe we've done that to show by our pool, by the status that Sheriff Leeper holds in the community, that the importance of his position in the community, an elected law enforcement officer, the chief law enforcement officer of the county. I think that the evidence reflects that the community is so pervasively exposed to the circumstances of this incident that prejudice, bias, and preconceived opinions are the natural result. That's the case of Manning versus State at 378, Southern 2nd, 274. And I've given a copy to the state. I think in this case where you have the facts of the community outpouring, the constant media penetration in this market, the show of love, emotion, and community support for Deputy Moyers, and the community reaction, all of those factors go into determining whether there's prejudice, bias, and preconceived opinions that have been formed. I think our survey underscores the fact that there are a large percentage of persons in this county that have a fixed opinion that Patrick McDowell should receive the death penalty. And I think more importantly, that a large number of persons believe that Mr. McDowell would have a difficult time, an uphill battle, convincing them that he should receive life without parole. So I think that that preconceived opinion is going to make it very difficult to select a juror. Obviously, in the case of Rolling, R-O-L-L-I-N-G versus State, 695 Southern 2nd, 278, which was the Gainesville student murders case, there was a huge venue change issue in that case. And the Florida Supreme Court said a two-prong analysis that says that you're first required to determine the extent and nature of any pretrial publicity. And then second, the court is required to assess the difficulty in selecting a jury. Now in Rawling, they were saying that they should go ahead and try to pick the jury, but our case is different because we have so many logistics and so many out-of-state witnesses and so much advanced planning that we would ask that the court decide the issue beforehand. And the Manning case says that the court can do that. There's not a bar to the court ruling on a venue change motion in advance. And finally, in State versus Knight, the Florida Supreme Court delineated the analytical steps a trial court must undertake. Again, evaluate the extent and nature of any pretrial publicity, including whether the publicity occurred in relation to the time of the crime and the trial. We have both of those here. We have intense, pervasive, and repetitive publicity at the time of the crime. And now, just less than a month before the trial, we have both media, television media and newsprint media in this market recounting all of the prior inflammatory stories. And also, the court must consider whether the publicity included inflammatory stories, whether the publicity favored the prosecution side of the story, and whether the size of the community exposed. That's State versus Knight at 866 7 2nd 1195. And I believe the evidence that we have presented here today establishes all of those factors.
Have any cases where courts have considered a situation where a defendant has already pled?
No, there are none on that. It's all on pretrial. But this, I mean, this is a trial, and we don't think that the fact that he's pleaded guilty already affects whether the jury can sit here without preconceived notions.
Opinions about whether death penalty should be imposed or not are completely separate from somebody who might have a predisposed opinion about someone's guilt or innocence.
That's right. So we're not raising that as an issue, but the two most important factors from the survey, I believe, are that I believe it was nearly 56% would have a difficult time imposing a sentence other than death. Let me go back. I don't have the report in front of me, but I'll have to look. But a number around that, no, it doesn't, because some people don't answer the question. It's not, some people don't, you have to look at the statistics and see, because some people say, I don't have an answer to that. I don't know, because I don't know is an option to each question. So it's not always exactly yes or no, 50,
I agree.
40.
So 44% of the people either have no opinion or don't agree that they have a strong opinion about whether or not.
That's right. Or they
punishment
didn't
should be
answer.
imposed.
Right. So that's what you have to look at, is how many answered and how many said, yes, we have a strong opinion, and how many said we don't have a strong opinion. But I think the most telling statistic was the number of people that would require, that said that they would have a hard time, that Mr. McDowell himself would have a hard time convincing them to impose a sentence of life rather than death. So I think that's the most telling of the statistics when we look at the possible jury pool here. It come in with a preconceived bias of death and of the attitude, the preconceived bias.
Is there anything that would compare that preconceived bias towards imposing capital punishment in this case versus in general, public? I mean, the public has, I'm sure there's been surveys on people's general preconceived ideas about imposing capital punishment.
Well, I'm sure there are, but it wouldn't be relevant to a case where we're,
Would absolutely be relevant, because in every case, there's going to be, people are going to come in to voir dire, and they're going to have an opinion one way or the other, regardless of what case it is. So understanding whether or not this particular case engenders more of a people to be inclined towards imposing the death penalty rather than the normal case that comes in is something that is important for my consideration, I would believe.
I can't agree with you there, because I think we have to look at the individualized circumstances of this case and the potential venire with the question presented by this case, not attitudes in general towards the death penalty.
Well, I agree, but what I'm trying to figure out is how much more does this case engender those attitudes than just a normal case that maybe doesn't have as much publicity?
But I don't think it's relevant. It's just not a relevant analysis, because we have to look at how much there is in this case,
Well,
not compared to.
if most of the time people just survey in a generic case, say 52% support strongly imposing capital punishment, and then in this case, it goes up 4% to 56%, that doesn't seem like the pretrial publicity's had a big impact
But Judge,
on those
if
views.
you look at the survey, and I'd be glad to recall the Dr. Edelman at the back, there's a cross analysis of the number of people who you can compare each answer. And so you can look and see. And so I kind of cut that short a little bit. He does talk about that and why these cross analyses of the questions are important. So someone that believes that he's already guilty, has an opinion about the death penalty, how does that interact? But we did not ask to have a survey on the general acceptance or rejection of the death penalty. I don't think it's relevant in a venue change case when you're looking at a fact-specific media penetration on this case and whether we select a jury that has not had a fixed opinion on a sentence or on Mr. McDowell's character before coming into court.
But I understand. Look, there's no denying that there's been a pervasive media coverage. In the 5 years I was up here, there's not been a case that gathered this much media attention, and I can't remember one in Fernandina Beach since I've been practicing that has either. So there are issues that have to be considered, no question. So I'm not trying to discount what the doctor's saying in the survey, but it would help to know how much greater that strong feeling towards capital punishment is in this case because of pretrial publicity over just what the general populace strongly believes in.
I believe the survey was designed to ferret that out, that's why the questions are asked in sequence to find out how much people knew, and then of those who knew, what was your opinion? So I think the survey does set that out. That's the whole point, is to determine, because of this pretrial publicity, have you created this feeling or have you developed this opinion? That's how the survey reads. And that's how the questions flow in the survey. They start out with the media coverage, and then the next step was, how has that influenced your take on your feeling about a possible sentence in this case? But that's how the questions were designed. And if you look at the survey, and also Dr. Edelman testified, it's a 3-step process. And the first is to see what the media penetration is. So it's solely limited to those people who have had the media exposure. And that's what we are saying necessitates the change of venue. And Judge, just one thing I wanted to say, oftentimes in a change of venue case, there's a second survey that's done in other counties to determine the likelihood of a fair jury in other counties. So obviously we have not done that. We don't have a suggestion, but the only thing that we would ask is that if this case ends up being venue changed, because of the 40+ witnesses we have coming from all the country and actually from across the world, we would ask that it be somewhere near an airport that has a major airport. So we're suggesting either like Orange County, Osceola County, Hillsborough County, Pinellas County, Palm Beach County, Broward County, places that have air service so that we can at least be able to manage expenses for some of the travel. All right, thank you.
Thank you, Your Honor.
Any thoughts? Any thoughts?
Your Honor, may it please the court. First, let me correct defense counsel. There is a case under like circumstances. It's the Rollins case. The case is cited at 695 Southern 2nd 278. The Rollins case, which everybody knows, it's very renowned, especially from anybody who has any ties to the University of Florida, was the murder of University of Florida students in Gainesville. That case, which is being cited, is particular only to the penalty phase, that there had been entered a plea of guilty in that respect. So it's actually on all fours when it comes to the facts and circumstances that we do have in this particular case. And it does make a difference, Your Honor. And I believe the court is correct in inquiring in regards to that, because the survey itself was talking about guilt or innocence, which is a foregone conclusion in this particular case. It is different when there's been exposure which would affect a juror's ability to presume the defendant innocent in a guilt phase of a particular trial. When we are proceeding solely as the penalty phase, there's one question for the juror. Each juror must consider and be able to consider both a potential life sentence or a potential death sentence. And that's with the instruction of the court and the evidence that is presented during the course of the penalty phase. And I do believe these type of surveys, particularly when it comes to this, is flawed because the exposure that the defense expert is talking about made it clear, and one of the statutory aggravating factors is present in this case. These jurors were aware of the fact that the victim in this case, Deputy Joshua Moyers, was a law enforcement officer. And under the law of the state of Florida, a juror can, based solely upon that single aggravating factor, after being instructed by the court and considering mitigation and aggravation based upon that one fact alone, could impose a death penalty. So I believe this type of survey is flawed, particularly when it's only 200 prospective jurors in a county that is far more populous than just a couple hundred people. But that facts of an aggravating factor which make the death penalty appropriate and could give rise to a single juror considering and imposing the death penalty, and the fact that even with that, only 57% of the people felt that.
That undermine your argument? Because what you're saying is that everybody's been exposed to the aggravators, but they sure haven't been exposed to the mitigators. And so, I mean, doesn't that sort of undermine your argument?
It doesn't, Your Honor, because anytime you go to trial, an example would be the Donald Smith trial in Duval County. One of the aggravating circumstances is that the child was under the age of 12. It's uncontested, just like it's uncontested here. And so when we go into jury selection, we are already knowing that an aggravating factor is going to be established beyond and to the exclusion of a reasonable doubt based upon the plea of guilty in this particular case. What is important for the juror at that point in time is to affirmatively be able to listen to the evidence that's presented in the courtroom and keep an open mind as to death and to life. And as long as they can affirmatively answer that question to the court's satisfaction, that they can be fair, they can be impartial, and they consider both options when weighing the evidence that's presented in trial and the law as the court will instruct them, then they are potential jurors in that case. And that was the key factor that is outlined, and that's why in the Rollins case, they discuss on whether or not there's a difficulty in selecting a jury is a factor that the court must consider, and whether or not the defendant had exhausted all of their peremptory strikes. The factors are, of course, the length of time that has passed since the incident took place, the news coverage and the inflammatory issues that are at play. And one thing I would comment is the survey actually is contradictory to the defense's argument. Nearly 70% of the people surveyed were unaware of the inflammatory comments of Sheriff Leeper. And so that's something to be considered. Whether or not the media coverage consisted of a pro-state version to the exclusion of the defense's version. I think once you review and you have the opportunity to review the media coverage in this particular case, there's a lot of coverage in this case that talks about the defendant's background and the defendant being involved in the military and the defendant having potentially PTSD and that being a factor. And all those aspects are covered in these news stories. And there was actually even a series that was conducted in the media coverage related to that particular aspect of the mitigation in this particular case. The size of the community obviously is also another factor. But most importantly too, when you look at the Knight case as well, and that's State v. Knight cited at 866 Southern 2nd 1195, that the selection process of the trial court utilizes is important. And I understand the court has not issued, because of these ongoing hearings, the court's trial order when it comes to the jury selection process, but you have given us an advance notice as to what that procedure is going to be. Exactly. And that process with the individual questioning of the jurors and the questionnaire that is going to be utilized, and that process that the court is going to implement is going to satisfy the concerns when it comes to whether or not the jurors have been improperly exposed to inflammatory information that would make it impossible for that juror to consider the evidence presented at trial and to consider both a life sentence or a death sentence. And so I believe that the process that the Knight court talks about is exactly what this court has talked about and is going to utilize in selecting a jury in this case. And frankly, I don't think logistics and cost are an overriding factor. While I understand it's a concern and all of us want to be good stewards of taxpayers' money, the state of Florida and the victim's family also have a compelling interest to try Patrick McDowell in the community in which he committed his crime, and that is Nassau County. And at this juncture, because the defendant has pled guilty, the only factor that we should be considering is whether or not we can impanel a juror that can be fair and impartial and consider both life as a possible sentence and death as a possible sentence.
Almost 30% of the jurors are going to have some connection to Deputy Moyers. I mean, that's a third of the folks that we're going to be considering know him. And, you know, it's going to be
I'm sorry, I can't hear under this air vent over here. I'm just coming to hear you.
Well, you,
It's just, the air vent makes so much noise over there. I'm so sorry. I just
the
can't.
the alternative for it not making noises is that it would be rather uncomfortable in here. So I apologize. I just said 30% of the people in that survey said they knew Deputy Moyers and connection to him.
I don't actually think that's what the survey says. No, the survey says that approximately 30% of the people either knew Deputy Moyers or knew somebody associated with the Nassau County Sheriff's Office. And so simply knowing somebody, if your next door neighbor is a member of the Nassau County Sheriff's Office, you're going to answer affirmatively in that response. It doesn't mean that you could not be fair and impartial and sit as a juror in that case simply because your next door neighbor works for the Nassau County Sheriff's Office. And so I don't believe that 30% of the 200 respondees knew the Moyers family or knew the victim personally, but the question was sort of, multifaceted in the sense that they either knew the victim or knew somebody who worked for the Nassau County Sheriff's Office. And I don't think necessarily answering that question in affirmatively would necessarily strike a person for cause.
No, following questions are going to be pretty probative of that and whether they would be
Absolutely.
able to, notwithstanding that relationship, follow the law. I mean, I don't know, I can't remember in this jurisdiction, this high profile case in one of the outer counties. And I could be wrong. I just can't remember Clay ever having anything like this. I can't remember Nassau having anything like this. My point is that there's been some, you reference like the Donald Smith case. But that's Jacksonville, but you're also pulling from, a population of almost 1 million people in Jacksonville. I have some concerns. This is, we have 90,000 plus people in this county. I can't remember, and correct me if I'm wrong, but I can't remember.
I think the murder of David White in Clay County is equivalent, where he was murdered executing a search warrant on a meth house in Clay County. That's not so far removed at this point in time. I think the Gerald Harrell case is another case that is comparable, where the young girl was kidnapped and murdered in Orange Park. I think that's also another case where the state was seeking the death penalty. There was an extraordinarily amount of outpouring of both support for the victim's family and notoriety, even nationally, in regards to the case. And that case was tried in Clay County. Judge, in all honesty, and I think we found this in trying the Donald Smith case. I think those of us who work within the criminal justice system are so familiar with the ongoings of the criminal justice system. We sometimes are jaded in this aspect of, I was shocked at the number of people who actually don't have as much knowledge as we think they might ought to have in regards to what we're doing down here. But more importantly, even if they have knowledge, and that's the key factor in the courts, in the Rollins case and the Knight case and the Manning case, even talk about this. Simply knowing about a media-worthy case, and this clearly is a media-worthy case, knowing about the facts is expected in a high-profile case of this nature. That's not the question. The question is, does your outside knowledge about the facts that are presented prevent you from doing your job as a juror, being a fair and impartial juror? And in this case, setting aside, guilt is a foregone conclusion. But in this case, knowing the facts in this case make it impossible for you to openly consider both life in prison and the death penalty as a possible punishment. And I don't believe that the survey, that the results, that the media coverage indicate that that is necessary before we even try. Now, I will admit to the court has already told us that we are going to summons nearly 1,000 citizens of Nassau County if we move forward, even more so, and that we are going to go through an extensive jury selection process. And throughout the course of that process, if the defense asks the court to reconsider the change of venue motion because it's becoming apparent that we cannot select the requisite number of jurors and alternates to try this case, then that is the appropriate time for the court to take up this motion, but the Rollins case and the Manning case dictate that that should be the case, and the logistics of this.
Case law says if there is absent an extreme or unusual situation, and this is the closest case I've had that might approach an extreme or unusual situation with the level of media coverage. We've had it up here with Kessler. I knew we'd get a jury up here, even though it was, it was covered extensively and everybody knew about the case and knew the family over in the west side of town, the county. But this is a little different. It's a little different.
Judge, respectfully, I would disagree. I don't think this case is extreme or unusual to the point where we don't try to select a jury first. I found it interesting that the expert even talked that he consulted on the Parkland case. There was no change of venue in that case, and that defendant got a life recommendation. And I don't think any case was more dramatic or it touched more tentacles of a community than 17 children and teachers being murdered in a high school.
For the venue change, so.
But then again, the defendant got a fair jury because he got a life recommendation. And so I do not find that the facts and circumstances are so extreme in this particular case, that the media coverage is so extreme, particularly because the defendant has already pled guilty and we're only here to determine punishment, that we should abandon the dictates of what is required under Rawlings and Manning, or not Manning, Rawlings and Knight, and even forego the attempt to try to, especially under the painstaking steps that the court has outlined to select a jury in this case, and change venue before we try. And like I said, I don't believe we're going to need to change the venue. I think we're going to be able to seat a fair and impartial juror in this case. If I'm proven wrong during the course of jury selection, then at that point in time, I think we have to take up a reconsider this.
This case will not be heard until probably the end of the year at the earliest.
In likelihood, Judge, even if the court were to grant the motion at this time before we try,
Still have to be
wouldn't be
moved.
trying the case before the
I
end of
agree,
the
I agree, because when it's being filed, the timing of this is such that there's no way I can get an alternative venue. But those are the realities we have to deal with. All right, you want to sum this up on your position?
Our position is, Judge, we believe we can get a fair and impartial juror, but more importantly, that based upon the law that has been presented in Rawlings and Knight, that this motion is thrown.
All right.
Judge, could I respond just briefly about Rollins? Oh, okay, thank you. Yeah, Rollins was in jury selection before he filed his motion for change of venue. He was on the 6th day of jury selection. So the motion was untimely, and that was part of the reason that it was denied. He actually, I believe he pled guilty during trial, if I'm not mistaken. Mr. Chipperfield knows, because I think he worked in Gainesville for 8 years, so he has a little bit more knowledge than I do, but.
Surprised to be called on.
Judge Rawlings was tried way before I got to Gainesville.
Judge, even if the group knows of an immutable aggravating circumstance, such as the police officer or law enforcement officer was the victim, the jury can always grant mercy. And there's no juror is ever required to vote for death. So the state's argument, I think, on that position fails. That it's not whether they have an immutable aggravating circumstance, it's whether the jury can set aside its preconceived notions. Again, the state didn't present any evidence in rebuttal to our survey. There's no evidence of this lot of coverage that they talked about Mr. McDowell being in the press. And I do agree that with the state that the Knight does say that the selection utilized is important, but except in the, as you pointed out, the egregious and unique circumstances. And I believe this case does set forth those circumstances. Thank you.
Want to thank counsel. Both sides. This is not an easy issue. It's not. It's not, I mean, you could just say, hey, let's just go ahead and try. And just make it simple, but it's not that simple. And I understand and I appreciate counsel on both sides and the efforts and the high level of advocacy that you both have provided here today. Quickly on scheduling note, I mean, my understanding is you all have told me now that the witness from the VA is set for tomorrow. Is that correct?
Tomorrow at 4 o'clock here on a via Zoom.
Is there anything else that we need to discuss in this?
I don't think there's anything else. He said he's gonna get it over out.
Okay, well, we need to probably have another status conference on this and perhaps next week. I'm just going to put for now, next Thursday, this is just for a placeholder. Next Thursday, which will, I guess would be March 28th, I guess, is next Thursday. Again, that's the past day as a placeholder. My office will reach out, as we've been doing, to coordinate with your calendars for another status conference, okay? For next week. The other thing you need to understand is right now, as we talked about, God's waited till today to at least as the earliest to consider whether or not I'm going to grant a venue change. That means the start date is now, at the earliest, is going to be April the 4th, Thursday. And if I decision on the motion today, which there's a high likelihood that that's probably the case because we're at 4:05 now. That means the first day, it would be the 5th of April, that Friday, if I were to render a decision by the close of business tomorrow, which is, there's a high likelihood that will happen. All right. So understand, and I understand the start date's a little flexible right now, and that's a little difficult, but we've got to follow, the clerk's office has to follow the statutory requirements for issuing a summons. And so just reminding everybody, and I'll probably email you just to let you know whether the decision will go out today or tomorrow. But I'm telling you, most likely I'll have a decision by tomorrow. That's going to be the earliest, okay?
That's just one other thing. I had filed a motion to take judicial notice, which the state had no objection to, and you had agreed, Sheriff Leaper's biography from his website, so I'd just like to file that with you.
Sure. I mean, it's already in the court file. I mean, it's already there, so.
It has shown up.
Yeah, I looked at it
Okay.
online.
All right,
I mean,
wanna make sure.
yeah, it's
It's
already.
faster here than it is in Walker.
Well, it's already online, so everything's there. Okay. And anything else from either side?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, well then I appreciate all. That will be in recess and my office will be in touch. Thank you.
All right.